Is this a new approach for the Supreme Court to say, we want to find a path of constitutionality for this law for you, since you haven't found it for yourself? And secondly, when John Roberts says that the individual mandate, the penalty is a tax, to me, this is a new definition of tax. It's not just a new definition of penalty. It's a new definition of tax. It's saying that if you don't engage in an activity, that the government can fine you, and that fine is a tax.
It's taxing inactivity.
I wanted to add to that. You're taxing behavior, which is really uncomfortable for me. What kind of legal precedent does that set?
Isn't it the absence of behavior?
Yes, the absence
of behavior.
Nothing.
You replace, they threw out,
tax.
you can't force activity under the Commerce Clause. You can't regulate inactivity, rather, but you can apparently tax inactivity. That was the bait and switch.
A negative.
So let me answer both of your questions. First of all, no, this is not new. There is precedent for it, and Justice Roberts quoted the precedent going back to Oliver Wendell Holmes in the 1920s and before, that the court should look for a path of constitutionality. Is this the first time we've attacked a behavior? Well, you know, Congress does all kinds of things to influence behavior. They give you tax credits. They encourage you to go green. They encourage you to have children with tax credits.
All activities, though.
They're all activities. That's fair. But Justice Roberts' justification for this, and this gets into very legal techniques, is that I can limit how taxes are used to influence behavior, where the heavy hand of regulation in the Commerce Clause is very stiff. Let me just say this, because we have to move to the Commerce Clause, but here is what those four justices you talked about, Alito, Scalia, Kennedy, and Thomas, said regarding the tax. Let's put up the tax writing. They said, to say that the individual mandate merely imposes a tax is not to interpret this statute, but to rewrite it. Judicial tax writing is particularly troubling. They're suggesting, those four dissenters, that the Supreme Court and Chief Justice John Roberts are not just legislating from the bench, they're writing tax law.
What's confusing to me is the purchase of that private product, the money, the dollars you spend, that transaction, is that considered the tax? Or is the penalty imposed on you for not engaging in that transaction?
Penalty is the answer.
So that means that the people who buy that product are not paying that tax because they're not getting that, penalty.
That's correct. That's correct.
Some people pay tax on this and other people don't.
They use
You only pay tax if you don't participate.
They use that as part of their justification, too. They said, well, some people will be exempted from this because they won't have enough money, so therefore that's the only way they try to get around the idea that the government is now under threat of force trying to take money from you for just being who you are, for just being in America.
This is not a $2.6 trillion tax on the American people.
Guys, I got to move on to the Commerce Clause. Listen, because I made this argument that I thought we lost the battle but might have won the war. Let me put up what the Commerce Clause said just again for one last time, that Congress shall have the power to regulate commerce among the states and foreign nations. Now listen, here's the theory out there. This opinion, and Chief Justice Roberts' opinion, came down on the argument that Congress can regulate inactivity very, very hard. He said, he adopted whole cloth the arguments we've had here. You simply cannot regulate inactivity. In fact, he said, let's put up what we have entitled full screen inactivity. He said, to an economist perhaps, there is no difference between activity and inactivity. Both have measurable economic effects on commerce, but the distinction between doing something and doing nothing would not have been lost on the framers. What I think happened today, I'm not suggesting that it did happen for sure, but it might have happened, is John Roberts shut the door on the Commerce Clause. The Commerce Clause, which has been a massive source of federal government power, the one that has written our federal criminal codes, our labor laws, the one that regulate a man growing wheat at his home. But he might have closed the door on it, and to evidence that, I would suggest to you this. Justice Ginsburg wrote a dissent where she tried her hardest to reopen it. She argued that point all the way. What possibly we might have seen here is the Commerce Clause closed, and yes, a taxing power.
I disagree because you're defending it basically on your own 10-yard line at this point. This would have meant no limits. This would have meant the Commerce Clause could be used for absolutely anything. It would have meant inactivity. So there's no victory here because the federal government did not assert the power to be able to do whatever it wants. By you breathing, you can be forced to do something. And I would offer you that, yes, maybe to some degree, they've kept this door closed a little bit on the Commerce Clause, and I guess conservatives are looking for a silver lining, but they've kicked the taxation door wide open now. I mean, the idea that you can sneak in a tax, it also takes away the power of the legislature here after the fact. And that's a huge problem they didn't address in any of the discussion and any of the opinions. They looked at this. This would not have been able to pass as a tax. They should have pushed it back down and said, look, we're not going to change the wording of your bill for you. As Scalia says, we're not going to, protect a bill that's not what it says. They should have passed it back down and allowed the Congress to try to push this through as a tax.
Incredibly true and incredibly important. This was called a tax. I mean, it was not called a tax at the legislative level. We have clips of President Obama saying this is not a tax. This was passed to the American people as not a tax. And now the Supreme Court comes in after the fact and says it was a tax. I get your concern, but listen,
argument.
There was never a limit on the taxing power. It was always broadly defined. The only difference now is you know it. The check on the taxing power has always been political. We're going to talk about it next with SC, but the check on taxing power was always political. And what I'm going to tell you is you have just seen the last time in American history that a legislative branch can say to you, we're passing something that's not a tax that turns out later to be a tax.
From just being